That handbook and which one? The grievance policy. Okay, as one document. So that one is not matters. DO4, while the federal, the Lufemi receipt is DO5. I've told the court this. The pictures of the vehicle Toyota is DO6. Record of the disciplinary hearing of 26 June DO7 and first Facebook and Instagram post DO8. Have you corrected the registrar? Yes. Can the witness hear the court?
Yes, I can hear.
Yes.
Yeah. Can you speak a little louder?
What do you want the Honorable Court to do for you?
I want the Honorable Court to grant my claims.
Yes, cross-examination. Mr. Pusha, how many minutes do you think you need for cross-examination? Yes. Now, I'm not going to give you 30 minutes because I have I think 4 other trials too. So can you look at your questions? So we'll go straight. Pardon? Let's start with 20 minutes. Yes, witness, can you hear the other counsel?
No, I can't, Your Honor. It's really low.
Okay, see, can you take my phone and keep it there? Say, patience or somebody hold this phone so that you put it on your table. Can we start with the cross-examination?
Let him come forward.
No. No, does he need to come forward?
Yes, my love.
Okay. Yes.
Mr. Lufemi, please, can you hear me?
I can hear you.
Okay, thank you. In paragraph 8 of your witness statement of oath, in paragraph 8 of your witness statement of oath, you
Go ahead.
stated that on account of your continuous impressive hard work and positive attitude towards your work, that you were promoted. Is that correct?
I was moved there. I was promoted as territory sales manager.
I am time bound, so I don't want to get to an exact answer. Is that correct? That was what you stated in paragraph 8 of
Yes.
your wish to promote. Is that correct? I just want you to confirm if that's correct.
Yes.
Did you tender any letter?
So you should use the other one that is.
What's your claim? Did you tender documents? Did you tender any documents to the court in support of your claim?
Which claim?
The question is, you just confirmed that as a result of your sterling performance and all of that, that you were promoted. And I have just asked you that did you present to this honorable court any letter from the defendant to support your claim?
Defendant didn't give me a letter. They normally send that through electronic communication.
So we can save time. Did you tender any document to support your claim?
Counsel, you have to listen to him. He said it was sent through electronic claim. Okay, you can't hear.
It was sent electronically. When you're promoted or given a new role, that's sent by email. So the defendant should have a copy of that email, because I don't have access to company email anymore.
question is, I think you don't get the question. What I'm saying, did you present it to the court? I'm not saying whether you said to the defendant. My question is simply, you said, you made a statement in paragraph 8, and I'm saying, the question I'm asking, just listen carefully, my brother, is that, did you present to this court, this honorable court, any letter to support your claim, not to the defendant? I'm not directing the question to the defendant, Mr. Defendant.
Oh, that's what I'm saying. Yeah, I can't present a letter when it was sent electronically to me as a designation. That's what
To the court? Did you send it electronically to the court?
No, I didn't send it electronically to the court. You couldn't have.
I don't think you understood my question. What I'm saying, did you present a letter that supports what you said in paragraph 8? Did you present it to this court? This court, you have documents that were presented to this court.
No, I didn't present a letter. I didn't present anyone about the promotion to this court. No.
You didn't present anything. That's all. Let's be on record. You didn't present anything. In paragraph 13, you stated that you were detained by the police for 6 hours. In paragraph 13 of your written statement of oath, you stated you were detained by the police for 6 hours. And in paragraph 17, you further stated you were detained for 20 hours. So you have 2 timelines, is that correct? You have 2 timelines for your detention by virtue of your written statement of oath. You have 2 timelines. I'll take it again. In paragraph 13, I believe your witness statement of oath is you. You stated in paragraph 13 that you were detained by the police for 6 hours. You were detained for 20 hours. I'm saying that by virtue of your written disposition of oath, you have 2 timelines for your detention. Is that correct?
Yeah, there was just one timeline. Just one timeline. And I know that I was in that station for over 6 hours.
That's what I'm saying. Is either it is one or the other. What I'm saying, paragraph 13, look at paragraph 13. You stated 6 hours. Then further down the line, in paragraph 17, you stated 20 hours. What I'm saying is that there are 2 timelines stated in your own written disposition on oath. Is that correct? I'm not saying whether it's one or the other. There are 2 timelines. You stated 2 timelines. Is that correct? You might want to look at your written disposition on oath. Do you want me to read it to you?
I'm looking at it.
So there are 2 timelines by your own written disposition on oath. Please, let's say the time.
No, there are not 2 timelines. Most likely an error on this one. There are not 2 timelines.
It's okay, it's okay. Paragraph 13 and 17 will be read by the court. Okay. In the course of your employment with the defendant, you engage in a business that is similar or the same with the defendant. Is that correct?
No,
Is that correct?
not correct. No, it's not correct.
Why is it recorded? Why is it echoing? No, you said no. I can't lower it. Okay. Right. I've lowered it.
But you engage in the business of class sale. Is that correct?
I did not.
You did not engage in the business of class sale.
No, I did not.
Okay. I want you to take a look at this document.
No, hi, just tell him he says he has all the documents before him. Okay, you want to.
Okay.
achieve the objective of
How are they going to share it now?
section 454. Can you see these documents?
Eh?
Now,
There's a way we show to the witness. How?
thank you. 3 documents.
How do you do it? Okay, that's it. Okay, that's it.
Can you see those documents?
Yes, I can see that document.
You said, what did you
You
say?
said you can see them.
Yeah, I can see the document.
That document has a name that is associated with it. And that
Ye-
name is about and that is you. Is that correct?
Yes, that's me. Yeah.
Because I said that the same document in support of.
Can I say something? Can you see the date on the document?
Can you repeat? What says it?
I asked the witness. Because I don't know where I have the witness.
Can you ask the question? Go ahead and ask so that we know that the witness understands your question.
Yes.
Can you ask put the question across to him again?
Was that there's a name that is on that document, and that document is Oba Okoja, and you are Oba Okoja. And you said yes. And I sought the legal document.
Witness, do you
Uh-huh.
understand the question put across by the defendant counsel?
Oh, the question is ambiguous. There's no direct question.
No, what? Just a moment. What's ambiguous about the question? You were shown some documents and you confirmed to the court that you can see the documents.
Yes.
And he says the document bears about Koji and you're about Koji. And you said
Yeah.
yes.
Yes, but
Is
he's
that not?
Yes, but he's not confirmed the date on the document as well.
The
And
date on the document. Is that
yes,
the date on the
yeah,
document?
there's a date on the document of the post. He needs to confirm that as well. You can't just confirm my name.
Is it what?
A month and a day on those documents.
Can we see the documents?
Yes, thank you, Your Honor.
There are 3 documents.
Let me see the documents. It has a date and time.
Yes,
One says 16th July, 15th December, and then 17th July.
thank you, Your Honor. And all
Ubaka
these,
Delcas.
yes, and all these dates are dates after I had been terminated from employment. So I was no longer in their employment.
He says, I will put it down and then look at it. He says the dates on the documents are dates after he had been terminated.
Has to prove. He who alleges in the school.
You are objecting to? Okay. I'll put it, but the document will be taken in and marked. Let me see how many documents. The documents tendered by the defendants are admitted in evidence and marked as exhibits D09 A, B, and C.
Witness.
Witness, can you hear us?
I hear you now, my lord.
I said My question is, you were employed on the 9th of October 2018 by the defendant. Is that correct?
Yes.
Yes.
On the 25th of February 2020, on the 25th of February 2020, a business name was incorporated. A business name was incorporated through your wife. Through your wife. A business name was incorporated through your wife. Is that correct?
Yes.
That business name, the object of that business was catering and auto sale. Is that correct?
Yes. Catering, just catering, not auto sales.
Auto sale
Catering.
and auto sale. Thank you.
He says it's just
Just
catering.
catering.
Catering and auto sale.
No. It was not catering and auto sales.
Do you stand by your answer that that business name was simply for catering?
Yes, and just normal business. It's my wife's
I need
business.
to clearly. Can you speak up? You do this.
It's my wife opened
See,
it.
this is the only one that you can hear through. So, so there's nothing. I don't know what is happening.
You know that I can't even hear you, but
Okay.
I'll rely on the records of the court after the proceedings.
Okay.
I just want you to confirm that that business name, by your own testimony this morning, you said it is only for catering. Is that correct?
I don't know anything about it. It's my wife's. That's my wife's. It's
No,
my
no,
wife.
That is what I'm saying. I put a question to you that the object of that business is catering and auto sale. You said no.
That's what I'm saying. I don't run the business, sir. I don't run the business. It's solely for my wife. My wife opened that and registered herself. I don't run it.
The question is this. That business was used to engage in auto sale.
That's what I'm saying. I don't know. Because I don't own the business.
Yes.
On the 29th of June 2020, you were dismissed from the employment of the defendant. Is that correct?
Right.
29th of June 2020, you were dismissed from the employment of the defendant for, among other matters, for gross misconduct. Is that correct? Among all the several allegations for gross misconduct. Is that correct?
Several allegations.
You were dismissed on the 29th of June 2020.
Yes, I was dismissed on 20th June 2020.
And I'm saying, among other allegations in that letter.
So you need, there was no other allegation. I don't know what other allegations that I'm saying. But yes, I was dismissed on 29th of June.
Before the court, there's no need to overput it. By virtue of your contract of employment, you contracted not to engage in a business that is similar to that of the defendant. Is that correct? By virtue of your contract of employment, you contracted not to engage in a business that is similar to that of the defendant. Is that correct?
So while I was in employment, yes, while I was in employment.
Mr. Okoje, this is yes or no. If it is yes, if it is no, it's no. So we can save time. You contract, if you didn't contract, the contract is before the court will reach. I am putting it to you. My question is, you contracted that you will not engage in a business that is similar to that of the defendant? Is a yes or no?
While in employment, yes.
Oh, that's it. That's not good sign.
No, counsel. He says yes, he he had a contract to that effect, but while in employment.
It's fine.
So-
But the court is going to read.
Yes, I will, but that is his answer. So it's important to take him. The next question.
No, my worry, even though technology and evidence can be given from many factors, my worry about it is that my Lord is denied of the opportunity of seeing the countenance of the witness.
Counsel, what do you want me to do? I did not apply to have this done through virtual hearing. It's one of you that applied, and I granted, but I'm not going to grant any more of that application because we don't have the facility. Yes.
I'm just highlighting that the court is denied of the opportunity of
But I can see him.
as the court.
I can see his demeanor.
As the court. So
I can see very well, and he's talking. My phone is working. Yes.
there was a disciplinary panel that was set up to look into the allegations against you. Is that correct?
Yes,
There
there
was
was.
a panel that was set up to look into the allegations against you.
So the
Before you-
yes, that was set up.
You made presentation
Paper.
to that disciplinary panel. You
Sorry,
made, you made a presentation to that disciplinary panel.
When you mean a presentation, I don't understand what presentation means. Can you be clear?
You were invited by that panel. Is that
Yes,
correct?
yes, correct.
Yes.
Do you know any company by the name DD's Empires? DD Empires. DD Empires.
Union Empire that I mentioned earlier is my wife's business.
No, I'm not asking that it's your wife or your sister or your brother. Do you know any company by the name DD's Empire?
Just mentioned that I know the company because my wife's business.
You know, like I couldn't hear what
He says he knows the company. I want to get my iPad.
I'm almost speaking. I'm almost running off. Now.
Yes, but I have other try, so I
Yes,
can get
yes.
ready for it. Yes.
DD Empires engages in auto sale.
No, I don't know. I don't know. Not to my knowledge.
Engages in auto sale.
Not to my knowledge, no.
You know, I didn't hear you.
He says not to his knowledge.
My final question to you is, Mr. Ubaka, is the information about the car. The information about the car. Mr. Gbemi called you. Mr. Gbemi called you to show interest in. The information about the car, Mr. Gbemi called you to show interest in. Was given to him by you. Was given to him by you. The information about the car.
Witness, can you hear the question put across?
I can hear the question.
So that's it. Was given to him by you. Because Mr. Gbemi is not a. It was given to him by you. Let me leave it at that.
What's your answer to that?
My answer to that, Your Honor, is that Mr. Gbemi was a fellow colleague at CAS 45. And And I was a sales manager at
I
the
didn't have
time.
information, Mr. Okoji. The
No,
information-
allow him to. You have put a question across to him. He should answer. Whatever he wants to give us answer, the court will consider later, but you don't expect him to give you the answer you want him to give you. He has an answer he wants to give.
I didn't give you the opportunity to explain. He's already
No, you want him to say yes or no?
He's already done that.
Yes.
It's okay. What's your answer to that, Mr.
Answer to that, Your Honor, is that Mr. Gbemi was a colleague at House 45 as well as myself. I was a sales manager during the period, and as a target, I had target to sell cars for the company. Mr. Gbemi was in the office on the day when he heard my conversation about pricing with someone who reported to me, who worked with me in that territory, and he showed interest. And what happened on that day was I gave him that sales agent's number to liaise with him on how we could sell cars in our territory. That's what happened.
Yes.
But the answer he gave are completely not for me. About
You too. But you didn't hear what he said. Okay, let me just read so that you can say Mr. Gbemi was a colleague at Cars 45. I was a sales manager and I had targets to sell cars and was in the office when he had my conversation about pricing. And he showed interest and I gave him the agent's number and he liaised with him on how we can sell cars in our territory.
what you just said could not have been true because Mr. Gbemi has left the employment of the defendant as at that time. Is that correct? Mr. Gbemi had resigned, had left the employment of the defendant as at that time.
Wouldn't know because it was during COVID period. Nobody had been in the office for a couple of months. And my first resumption to the office during that COVID period, I met Mr. Gbemi in another manager's office on the day. There was no communication via electronic or letter about Gbemi's resignation or not being in the office. And there was no way we could have known while in lockdown.
Again, Mr. Ubaka, I said, as at that time, that information got to you, Mr. Gbemi had earlier on left the employment of the defendant.
And I just told you that I wouldn't know, Your Honor, I wouldn't know because there was no communication to me to say that Gbemi was no longer a staff. As I told you, I met Gbemi in the office.
This incident took place in the month of June. Is that correct?
It's in the month of June.
Took place in the month of June, right?
Yes, please.
And Mr. Gbemi resigned from the employment of the defendants in April.
Do not know. I don't know. I wouldn't know.
He resigned in April, so he couldn't have been in the premises of the defendant.
No, that's impossible because I met him in Mandela's office.
Let me look at that letter. Well, on a fact finding here, you have to be honest.
Okay. Sure. Can you see the letter? Can you read through? Can you read it?
I can't read it. It's small print, but I can see Gbemi's name.
Yeah, the dates.
I can see resignation of appointments.
Gbemi left in April. So
Okay.
there was a conversation in the office and he wasn't because we see the tender that says. to demonstrate that the witness is not a witness of truth.
Also, Your Honor, can I say something?
Just one moment, yes.
Thank you.
Yes, just one moment.
My straight answer to my learned friend's objection is the answer has section 223 of the Evidence Act. Section 223
Mr. Puter, I hope you allow me for the document to be marked and for the court before you start. Let me mark it. Yes. Where did we stop now? Oh, is it D.O. now? The document tendered by the defendant is admitted in evidence and marked as Exhibit D.O.10. Yes.
You know, the document has been given the power of the issue
So,
when the victim gets this application.
okay.
You know, that would be awful.
Any re-examination, Mrs. Idris? There was a re-examination.
Your previous state of employment has 45. When an employee resigns, are there any form of notification for that employee?
Are there any form of what? Witness, can you hear the question? Can you hear the examination?
I didn't hear the question.
Just wait. Yes. Can you put the question across again to the witness?
As 45. When an employee resigns, are there any form of notification to other employees?
No, there's none.
In case of
No.
is there any-
In case of what?
in case of document just entered, CO10.
Can you hear your counsel?
I can't hear her. She said something about a document.
In the case of Exhibit D10, the Gbemi's letter of resignation, were you in any form
No,
had any knowledge of the said document?
no.
Counsel,
Accomplices.
it is a re-examination.
Accomplices.
It is for you to clear ambiguity, not for you to raise a different question.
As a
If you
culprit.
have to clear ambiguity, it means the questions put across is not clear.
As a
So you want to clarify. But in this case, you are talking about resignation. So I don't take that as a re-examination. So let's give a date for defense.
But prayer would be that it's subject to the already coordinated determining that the dates that is coordinated in the information.
But it's not going to be done virtually. No, not at all. Okay, what date? 14th of May? No, you can't even do April.
This matter was filed in 2020.
I still have 2013 matter in this court. This is 2020. Mr. Puter, we do not have, you see, he gave you a date based on what is available. I'm not using my diary to give dates. The registrar is doing that. So he has given you a date based on what is available. So 20th of May, what date did you give? What date? 14th. Oh, 14th of May, not even 20th. 14th of May. 14th of May. Okay. Defendant, 14th of May.
it's like a Christmas package that we are not open, so we are going to come. Okay. We have no choice. Okay. Continue with me. Beloved, we are grateful to the courts.
This matter is adjourned to May 14th, 2025 for the defendant to open its defense. Don't call another one. Not yet. That's it. Yes, counsel? Yes. You asked for what? Okay, so it's not going on. Are you for the claimant or for the witness? Okay, and who applied? Who made application? You. Okay, so it's not going on. You are going to come back. You are not going to have any more physical, this is not virtual hearing. It's going to be physical. Let me have the file. What's your number? Let me do it. I give you a date, but it's for physical, both parties, for the claimant and for the defendant. Pardon? That's what I'm saying. I am going to set that aside. And then you have to come physical. You have to come physical. The claimant has to come physical from wherever he or she is. If you're not taking the matter today, I'm not giving any adjournment based on what I have earlier granted. I'm not supposed to be sitting today. I have judgments, but I decided to clear the backlog. So if you're not taking the opportunity, you have to bring the claimant physically. I'm going to put it. What's your own case so that I can give you a date to go before we continue? What is the name of your own case? Pardon? Okay, Tracy Wonderful. So when I make my order, you're not satisfied, you appeal. Once the Court of Appeal says I must do it through virtual, I'll start. But that is what I'm going to do. Counsel, let them call your case now, and then I'll make my order. After that, take whatever step you want to take. Is that allowed? If you're staying for your case, you stay, and then I'll hear the matter today. Other than that, you have to come physically. The claimant has to come physically. I'll give you any other opportunity. See the time it has taken us to get to this? The claimant is talking through my phone. Others can hardly hear. I didn't bring the phone. I just said, let me bring it as a backup, not that it's supposed to be used. So do you want your case called now so that I can give you a date? Okay. I am not going to do that. I'm going to make an order that the claimant has to come physically. And then the earlier application granted, I'll set aside the order. And I'll give my reasons. So can call the matter.
And Global Manpower Limited.
Yes, counsel. KPA Ubaka. Okay, for. Yes, counsel. Yes, counsel, Mr. Ubaka.
However, before the court, we have a election. Payments from lady
That she's a.
scheduled to undergo medical procedure. The event in the UK, the letter before.
So In other words, it is not the defendant that is asking for an adjournment, because I don't understand. Initially, you said that the defendant has an arbitration at 12. Is that not what you told the court? No, no, just one moment. Let me hear from the. Yes, that is why I have taken the matter, because you say it's not going on. Okay. The defendant is solely on the claimant. Okay. Okay, he said that the claimant is to undergo a medical procedure. Okay. Yes. You shall be craving what? Yes, let me hear from Defense Counsel, Messrs. Shodipo.
We received a letter from the payment council. We informed us that the payment is undergoing logical operation. I think that today the trial will be.
Mr. Bupani, if I may ask, when the case came up on the 12th of May 2023, was it through virtual or because the claimant was not in the country then? It was virtual. Why did the matter not continue on that day? Was not what? This matter is slated for virtual hearing today, that is, for the claimants to join the proceedings virtually and continue trial. The application for virtual hearing was granted on 21st of June 2022. The case was then adjourned to 7th of December 2022, but the court did not sit due to an official assignment. The case came up on the 12th of May 2023 and trial commenced virtually. The case could not go on as one of the statements on oath was not in the court's file. The defendant's counsel also informed the court that she needed to file a motion to substitute the witness. Today, after two adjournments, that is on the 24th of November and 7th of November 2024, respectively, the claimant counsel informed the court that the matter cannot go on as the claimant has medical appointment. He prayed for an adjournment. The court will grant an adjournment due to application on medical reasons by the claimant's counsel, but the trial will be done physically. As the opportunity presented twice by the court has not been taken by the claimant, the court, in view of the numerous virtual cases and backlog, early application granted is no longer applicable to the claimants. Let's give a date for physical. Application for what? To amend? Have you filed? But I'm not going to take it now because I have a time lag. Because you know, this time is given to us from Abuja, not the one controlling it. So what will happen is I'll give you a date. You have, let me see, the application is here. The what? Oh, okay, let me see. No, but the motion is not before the courts. Filed yesterday. It's not before the courts. It's not before the courts. So it's not before because I cannot give you a date for hearing. I have to give you a date for continuation of trial. No, I cannot take that. Just to pass through the registry so I can have a copy. So let's give them a date for trial. No, you can take the application since it's unopposed. We take the application and then continue with the trial. You know the claimant has been sworn in. Pardon? What you are talking about is not before the courts. I can't give you a date based on what is not before the courts. I can't say it's for hearing. We have commenced trial in this matter, Mr. Bukpani. Remember, the claimant had been sworn in, but because one of the statement on oath, I think the reply to the statement was not in the court's file. We couldn't continue. So I adjourned for today. And today you say she has appointments. So what will happen is that I'll give you a date for continuation of trial. So what you can do is that since the defendant is not objecting to this motion, they can do their consequential amendments and I will deem it as properly filed on the next adjourned date and then go on with the trial. So that day we're not going to wait. I can take your own. No, I don't know who is amending. No, I don't understand. Have you filed the application before? Or you have just filed now? Okay. So you didn't file a clean copy. Is it the proposed? You just filed the proposed. So it's not a consequential now. So what will happen is that on that day you make an application for it to be deemed as properly filed and served, because you know we cannot deem the proposed amendments. So what you have to do is to file clean copies and also serve same on the defendant to make it easy. So on that day you have your documents, the proposed that will be taken, and then you have the clean copy, so it will be deemed. And then the defendant can file the consequential amendment if need be, arising from your own amendment. And the court will also deem their own processes as properly filed and served. And then we go on with the trial. So let's give you a date for continuation of trial.
19th of May.
19th of May. Defendant, 19th of May, is it convenient? So since you have documents to amend, you couldn't have continued with trial today, counsel. I don't understand. You're not ready for the case to go, or you would have.
So yesterday I just thought about it. If I know the major is while I'm amending, so I didn't sign this process and I'll need the process. So just basically amending my interview. So yesterday I did not cross my mind.
Okay. This matter is adjourned to May 19th, 2025 for continuation of trial.